and inherently that means do the right thing by the law. So that's sort of enough about me. Just to touch on and to continue with something that Ndumiso said there about whether the law favors the tenants. We hear that a lot. The law favors the tenants. I agree that that might be the case to a certain extent. However, the law doesn't necessarily favor the tenants. It's just that a lot of landlords, a lot of property investors don't actually invest in understanding the law and making sure they are doing the right thing. If you do the right thing by the letter of the law, then I don't believe it necessarily favors the tenants. Then I think we're on an even playing field. It was created, obviously, to favor, to protect tenants generally, because the thought behind the law is that landlords are in a stronger position because they own the rental property, and tenants are in a weaker position when it comes to the legalistic side of things. So I think what you guys are doing today is exactly what all property investors should be doing, getting to know at least the basics of the law. The law can get tricky. We are going to try and keep it reasonably simple today. I have the Act open in front of me, but I'm not going to read it. I'm going to essentially pull out what I think are some of the most important parts of the Rental Housing Act. Firstly, I have to say to you, I'm not a lawyer. I have to cover my behinds there. I'm not a lawyer. I can't provide legal advice. I am just simply somebody who's still alive after being in the rental industry for 20 years. So I have a lot of practical experience. And as we go through today, I will give you some practical examples, or as you have questions, I might give you examples. So please feel free to ask questions as we go through. The first thing that I think is important to understand about the Rental Housing Act, and I hope I'm not talking too fast. I said to Ndumiso earlier, I go into presentation mode. So I'm trying to be conversational today. So if I look at the purpose of the Rental Housing Act, in the Act, they write a whole lot of stuff about promoting the rental market and all sorts of things. But I think from our perspective, there's two important things. Firstly, it's to manage the relationship between tenants and landlords. In other words, the lease relationship. And that's an important point because the Rental Housing Act generally, because it manages or it is applicable to the relationship between a tenant or tenants and landlords, we are talking generally, very generally, about the fact that there is already a lease in place. The Rental Housing Act will normally only apply once there's a lease in place. There is one exception to that, and there's only one exception that I'm aware of, and that has to do with discrimination on various bases. And that the Rental Housing Act governs from the moment the property is advertised. We cannot discriminate in any way, shape, or form, even when advertising a property. But we'll touch on that as we go through. So to me, that's the first important thing, is to manage that relationship between the tenant and the landlord once there's a lease agreement in place. And there's a whole lot of gobbledygook in the Act about that. The other thing that the Act does that is incredibly important is it makes provision for the establishment of the Rental Housing Tribunal. The Rental Housing Tribunal exists because of the Rental Housing Act. And the Rental Housing Tribunal is obviously all over the country in different provincial guises or forms, but it is throughout the country, and it gives both tenants and landlords, and there's a big misunderstanding there. It gives both tenants and landlords recourse to an independent third party that can take a decision on a matter. You know, it's not unusual for example, when we're in the rental agent business, at the end of the lease to have a dispute or a difference of opinion. Let's rather call it a difference of opinion. A dispute sort of sounds like when you want to hit someone. A difference of opinion about what is wear and tear and what can be deducted from the deposit for damages. That is a common point of the tenant-landlord relationship where there are differences of opinions. And sometimes we can agree to disagree, but sometimes we can't agree to disagree. And what I generally would say to the tenant is, I fully understand that you're not in agreement with me. I have 20 years of experience. I think I know the difference between wear and tear, etc. However, you're very fortunate because the Rental Housing Act has created this forum, okay, which costs nothing. It has created this forum where you can go and you can put your case in front of independent adjudicators. And they are authorized in terms of this act to take a decision. And that decision is binding. So my landlord and I will have to abide by that decision. So although you and I can't agree, let's take it there. Let's take it there and let them take the decision. And the Rental Housing Tribunal, I'm not going to go into it too much, but an order of the Rental Housing Tribunal has got the same standing in law as a court order from a magistrate's court. So unfortunately, that's sort of positive, but it's also a bit negative, because at the moment, if you want to appeal a Rental Housing Tribunal order, and the order is the same status of a magistrate's court, you've got to appeal it in a high court, which of course is unaffordable for most people. But the fact of the matter is we have a forum where both landlords and tenants for no cost can take a dispute and a binding decision can be taken that's binding on all parties. So those to me are the two most important purposes of the Rental Housing Act, is to establish the tribunal and give people a resolution mechanism which is affordable, and to provide some rules, some ground rules for managing that relationship between the landlord and the tenant. And because we're conversational, I'm going to sort of lead immediately into the fact that one of the realities in South Africa is that a lease does not have to be in writing. The Rental Housing Act does not require a lease to be in writing. So people can actually have a